Dear learners, I am here to discuss with you on the topic General Exceptions to Criminal Liability, Abetment and Criminal Conspiracy, and Attempts to Commit Criminal Offences. To begin with the first topic, that is General Exceptions to Criminal Liability, the very first question that comes up in the mind is what is general exceptions? It is generally presumed that a person is well aware of his act and thus is responsible for it under law. But then, there are certain exceptions to it. Section 76 to 106 deals with such exceptions under the heading General Exceptions. General exceptions contained in Section 76 to 106 under Chapter 4 makes an offence a non-offence. General exceptions are basically categorized into two categories: excusable defenses and justifiable defenses. The excusable defenses are the one where the acts are excused for want of necessary mens rea. In case of justifiable defenses, the acts are not excused but justified. Now, we shall be discussing about such justifiable defenses. First, mistake of fact and mistake of law. Section 76 and 79 of the IPC deals with mistake as an exception to criminal liability. These two sections are premised on the principle that ignorance of fact is excused, but ignorance of law is non-excusable. Under Section 76, a person is excused from criminal liability when he is bound by law to do something and has done it, or in good faith, owing to a mistake of fact, believes himself bound by law to do something and has done it. Under Section 79, a person is excused from criminal liability when he, in good faith, believes by reason of mistake of fact and not by reason of mistake of law, and he considers himself justified by law to do an act in a particular manner. Now, these two sections, though identical, are distinct from each other. Under Section 76, a person is assumed to be bound, whereas in Section 79, a person is justified in law to do something. Moving to the next category, that is accident. Now, Section 80 of the Indian Penal Code exempts a person from criminal liability if the act is done accidentally and that accident has occurred while doing a lawful act in a lawful manner and by lawful means wherein due care and caution is exercised. Next, we shall be talking about necessity. Now, Section 81 of the Indian Penal Code recognizes and embodies the doctrine of necessity as a defense against criminal liability. Section 81 embodies the principle where the accused chooses lesser evil in order to avert the bigger, then he is immune. Section 80 and 81 are analogous provisions. Now, Section 80 deals with accidents and Section 81 deals with inevitable accidents. Now, Section 80 stipulates the absence of criminal intention as well as criminal knowledge. But in Section 81, it stipulates the absence of criminal intention alone. Next, we shall be discussing about infancy. Section 82 and 83 of the Indian Penal Code confers immunity from criminal liability to child offenders. Now, Section 22 presumes that a child below the age of 7 years is doli incapax. That is, the child is incapable of committing a crime and cannot be guilty of any offense and thus totally absolves a child below 7 years of age from criminal liability. Section 83 presumes the child above 7 years and below 12 years of age is doli capex. that is capable of committing a crime depending upon the maturity of understanding of the child. Next, we shall discuss about insanity. Now, Section 84 of the Indian Penal Code states that unsoundness of mind is a defense of a person to a criminal charge. And why is it a defense? It's a defense premised on the theory that one who is insane has no mind and hence cannot have the necessary mens rea to commit the crime. Section 84 basically embodies the principles that has been laid down in the famous M19 case. However, the word insanity is not used in Section 84 under IPC. Section 84 uses the word, unsoundness of mind, which is again not defined in IPC. But then there are many cases where the courts have said that the unsoundness of mind is equated with the same thing as the meaning of insanity as laid down in M19's case. Now, according to the Section 84, a person of unsound mind is the one who is, 1, incapable of knowing the nature of the act, or 2nd, that he is doing what is either wrong or contrary to the law. 3rd, the alleged unsoundness of mind has to be judged in relation to the moment of time when the act was done. Next, we shall look into intoxication. Section 85 and 86 of IPC talks about intoxication. Now, Section 85 of IPC lays down the law relating to involuntary intoxication or drunkenness as a defense to criminal charge. Whereas Section 86 of IPC deals with criminal liability of a voluntarily intoxicated person when he commits an offense under the influence of self-administered intoxicant. Now we shall look into the right of private defense. Now, Section 96 to Section 106 of the Indian Penal Code deals with the law of private defense of body and property. Now, Section 96 lays down the right of private defense, stating that nothing is an offense which is done in exercise of right of private defense. Section 97 divides the right of private defense into 2 parts. The first part deals with the defense of person, and the second part deals with defense of property. Now, it provides, that is Section 97 provides, that subject to the restrictions contained in Section 99, which we'll look into in some time, what this, restrictions are. Every man has a right to defend his own body and the body of any other person against any offense affecting human body, and to defend his property and the property of any other person, whether movable or immovable. Now, Section 98 provides that the right of private defense extends to acts which would be offense, but for the fact that they are acts of youth, persons of unsound mind, acts of intoxicated persons, and acts done under misconception. Section 99, as I already said, lays down restrictions. Basically, it stipulates the acts against which the right of private defense does not arise. Now, it says there is no right of private defense against an act done or attempted to be done by a public servant, or an act done or attempted to be done by direction of a public servant, unless it causes reasonable apprehension of death or of grievous hurt, so long as the public servant acts legally. Now, it also states that right of private defense is not available when there is time available for having recourse to public authorities. It further states that the right of private defense in no case should exceed, the quantum of harm that may be necessary for the purpose of defense. Section 100 of the IPC recognizes the right to private defense of the body And it says the right to private defense of the body extends in certain circumstances to the extent of causing death of the aggressor when the assault is of any of such categories, which I'm going to talk about. One, if the assault is like to kill or cause grievous hurt. Second, assault to commit rape or gratify unnatural lust. Assault to kidnap or abduct. Assault to commit wrongful confinement. Assault, acts of throwing or administering acid or attempt thereof. Now, Section 101 of the IPC extends the right of private defense and says that it will extend to causing harm and not death in all other situations except as provided under Section 100. Section 102 of the IPC lays down that the right of private defense commences, as soon as a reasonable apprehension of danger. And that apprehension of danger, that is reasonable apprehension of danger, is about to the body arises from an attempt or threat to commit the offense, though the offense may not have been committed. Section 103 of the IPC provides that the right to private defense of property will extend to causing death subject to the restrictions imposed under Section 99. If, following offenses that I'm going to talk about are attempted to be committed or have been committed. One, robbery. Second, housebreaking by night. Third, mischief by fire committed on any building, tent, or vessel which is used as a human dwelling or as a place for the custody of property. Fourth, theft, mischief, or house trespass which are committed under circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequence of such offense if the right of private defense is not exercised. Coming to Section 104 of IPC, it extends the right of private defense, and it says that the right of private defense will extend to causing harm and not death in all other situations except as provided in Section 103 of the IPC. Now, according to Section 105, the right of private defense of property commences when a reasonable apprehension of danger to the property commences. You come to Section 106 of IPC and you will find that it says when there is a deadly assault on a person which causes a reasonable apprehension of death and his right of private defense cannot be effectively exercised without causing harm to innocent persons, then in such situation, any harm caused to innocent persons is also protected by law. Now, I shall move on to the next topic, that is abetment. Now, Chapter 5 of the Indian Penal Code provides for law governing the liability of all those persons who are considered in law to have abetted the commission of offences. Now, Section 107 of the Indian Penal Code defines abetment of a thing, and it does not define any offence. Now, under Section 107 of the IPC, a person is said to have abetted a thing if he has, first, instigated any person to do that thing, second, engages with one or more other persons in any conspiracy for the doing of that thing, or third, intentionally aids by any act or illegal omission the doing of that thing. Now, thus we see from this that whenever we talk about abetment, abetment may be by three ways. One is by instigation, second by conspiracy, and the third by intentional aiding. Now, here we need to understand what is abetment by instigation. Now, see, a person is said to instigate another to an act when he actively suggests or, stimulates him to their act by any means of language. Now, instigation can be in any form The instigation may be also by conduct. Next, we'll try to understand what is abetment by conspiracy. Now see, conspiracy consists in a combination and agreement by persons to do some illegal act or effect a legal purpose by any illegal mean. Now, abetment of conspiracy basically requires proof of three constituent elements. Now, what are these? 1. The abettor has engaged with one or more persons in a conspiracy. Second, the conspiracy was for doing of the thing abetted. And third, an act or illegal omission has taken place in pursuance of that conspiracy and in order to the doing of the thing. Now remember, abetment by conspiracy and conspiracy are basically two distinct offenses. In case of abetment by conspiracy, mere agreement is not enough. An act or illegal omission must take place in pursuance of the conspiracy and in order to the doing of the thing conspired for. Whereas, in the offense of conspiracy, the very agreement or plot is an act in itself and is the gist of the offense. Now let's try to understand what is abetment by intentional aiding. Now see, when I discuss section 107 of IPC, I did say that a person abets the doing of a thing who intentionally aids the doing of that thing. Now, what is this intentional aiding? Now, intentional aid consists of any of the following three components that I'm going to talk about right now. First, doing of an act directly assisting the commission of the crime or illegally omitting to do a thing which one is bound to do, or doing of an act which may facilitate the commission of the crime by another. Now, I move on to the next topic, that is criminal conspiracy. Now, sections 120 and 120A and 120B of the Indian Penal Code under Chapter 5A deals with criminal conspiracy. Now, these sections, that is section 120A and 120B, has been inserted by way of Criminal Law Amendment Act of 1913 with a view to make criminal of conspiracy a substantive offense. Now, section 120A of the Indian Penal Code lays down that criminal conspiracy envisages an agreement between two or more persons to commit an offense or carry out an illegal act by unlawful means. Section 120B is the punishing section for the offense of criminal conspiracy, and which is defined, as I said, the criminal conspiracy which is defined in section 120A of IPC. Now, for the purpose of punishment, section 120B divides criminal conspiracy into two categories. A party to a conspiracy to commit a serious offense is, in the absence of any express provision in the IPC, punished in the same manner as if he had abetted the offense. Now, conspiracies to commit any other offense, say including offenses punishable only with fine, and conspiracies to commit illegal acts other than offenses are subjected to a uniform punishment. Namely, it might be imprisonment for a term of up to 6 months with or without fine or both. Now, when the conspiracy, alleged is with regard to committing a serious crime of the nature contemplated in section 120B, read with the proviso to section 120A, then in that event, mere proof of agreement between the accused for commission of such a crime alone is enough to bring about conviction under Section 120B, and the proof of an overt act by the accused or by any one of them would not be necessary. There is basically no requirement that each and every one of the conspirators must commit some overt act towards the fulfillment of the object of the conspiracy. Now, I'll move on to the last topic for today's discussion, which is on attempt to commit criminal offenses. See, an attempt to commit a crime is an offense in itself, even though the crime has not, or the intended crime has not been committed. The Indian Penal Code, across many sections, have dealt with criminal attempt. And when I try to categorize that, then I can say this has been done. That is, the criminal attempt has been categorized into 4 ways. First, the commission of an offense and the attempt to commit the offense are dealt within the same section. Now, these attempts are, let's say, offenses against the state, which can be found across sections 121, 124, 124A, 125, 130. Then, abetting mutiny, which is laid down in section 131 of the IPC. Next, offenses against public tranquility, which can be found under sections 152 and 153A. Then we can talk about offenses against public justice, which can be found in sections 196, 108, 200, and 213. Then we can talk about offenses relating to coins and government stamps, as laid down under sections 239 to 241 and 251. Then we can talk about offenses relating to extortion, robbery, and dacoity, that is to be found under sections, let's say, 385, 387, 389, 391, 397, and 398. And we can also talk about criminal trespass, which can be found under section 460. Now, the next category regarding criminal attempt are the one where we find attempt to commit, specific offenses are alongside with the offenses themselves. But separately and separate punishments are provided for the attempts and the offenses. Now, such offenses are, let's say, take for example, attempt to commit murder, section 307. You talk about attempt to commit culpable homicide not amounting to murder, section 308. You talk about attempt to commit robbery. The other category that is laid down in IPC is attempt to commit suicide, which is in section 307. And the other one, the last category, is attempt to commit offenses for which there is no specific punishment provided in IPC. Let's talk about section 511, which lays down general principles relating to attempts in India. And it is basically a catch-all attempts penal provision. So this is about, attempts to commit criminal offenses. Dear learners, at the end, I would like to say that from what we discussed today, that is on the topic of general exceptions to criminal liability, abetment, criminal conspiracy, and attempt to criminal offenses, we have seen that how these provisions have been laid down in the Indian Penal Code. But if I have to suffice it and speak about these concepts, I would say that when you talk about the general exceptions on criminal liability, which is bedrocked on the concept that, there are certain situations wherein a person may have to commit an act which in general situation would have resulted into an offense. But because of the nature and the reasons by which it has been committed, it has to be, extenuated. That criminal liability has to be extenuated. Now, if you look into, and when we discussed about it from section 76 to 106 of the Indian Penal Code, we did see that these sections are talking about such exemptions, and these sections are to be read against all the sections that are there in the IPC. The very reason why all the sections, that is from section 76 to 106, had been brought down in one chapter is the reason that there should not be a felt need of repeating these sections against all other sections that is there. That is, after every sections in IPC, you do not need to add this, sections which talks about the general exceptions. And that is what can be found out in section 6 of the Indian Penal Code. The introduction of this concept of, abatement into the IPC also talks about and recognizes, cases or situations wherein a crime could not have been done by the person who has done, but with the help of some other person, who has helped him to do that act. So abatement, which we looked into by way of, say, aiding, instigation, which we did talk about, or by abatement by conspiracy, this shows that, it tries to take into consideration even those people who, even though are not, the one who has committed the offense, but has abetted, has helped the other person commit the offense. You come to criminal conspiracy that we have discussed under IPC, where we have seen that how the introduction of criminal conspiracy under section 120A and 120B does away with the thing that where we are actually recognizing the intention of a person to commit an offense and making it as accountable. You come to attempt to commit criminal offenses. Now, there might be, the felt need that there are offenses which, even though have not been committed, but needs to be sanctioned because there has been attempt to commit that offense. So, while we discussed, about abatement, attempt to commit criminal offenses, we did see that how an attempt to commit a crime is an offense and has been recognized as an offense, even though the crime has not been committed. So this is about what we discussed in today's learning.